Haley Fortuna Gill on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Jackson, who is standing to my right.
Okay, Mr. Jackson. We were scheduled for a hearing today.
That's correct.
Okay. Looks like, did I see you on the 16th of June? I think is the last time I saw you. Is that accurate?
16th is when you last year here, correct?
Yes.
Okay, and my understanding is that since then, there's been two confirmed or allegations of confirmed consumptions of alcohol, June 20th, June 21st, June 22nd. And are we having a hearing today?
You're not, Your Honor.
Okay, you want to plead guilty? Just raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Okay, put your hand down, sir, and you understand that you have the right to have a petition hearing on these allegations that you violated your probation by consumption of alcohol on various states. You understand that? Okay, and you wish to waive your hearing and plead guilty to these violations?
Yes, sir.
I'm just trying to see if this, oh, this is the old one, so it's supposed to be the new ones there. Okay. Okay, I think the violations that we are scheduled for hearing today, signed by Judge Buchanan in my absence, for failure to follow conditions of 4-02765. This is one violation. Another violation is for a confirmed scram tether from June 2nd. That began at 6:16 p.m. on June 2nd and ended at 8 a.m. on June 3rd with a peak TAC of 0.062%. Another violation per Aberhart that he failed to test on May 21st, 2025. Another violation of a confirmed scram consumption on May 10th, 2025, that began at 3:02 a.m. on May 10th, 2025, and ended at 2:22 a.m. on May 11th, 2025, with a peak TAC of 0.08% for JSG scram confirmation consumption on May 26th, 2025, and that the event began on at 4 p.m. on May 26th and ended at 7 p.m. on May 27th with a peak TAC of 0.055%. Those are the violations he will be pleading guilty to.
Yes.
Okay, and it looks like I did sign a new warrant on the 23rd for probation violations per JSG scram. Confirmed consumption began at 11:20 p.m. June 9th and ended at 2:10 p.m. on June 10th. Peak TAC of 0.109 per JSG. And there was a scram confirmed consumption that began at 8:55 p.m. on June 18th and ended at 8:56 p.m. on June 19th. Peak TAC 0.202. And lastly, per JSG scram confirmed consumption, first event began at 1:30 a.m. on June 20th and ended at 9:09 a.m. June 20th, peak TAC 0.043. Second event began at 9:15 p.m. on June 21st and ended at 8:02 a.m. on June 22nd, 2025, with a peak TAC of 0.05. And would you be pleading not guilty to those, or is he
Guilty. All charges.
and you understand your right to have a hearing, correct? Okay, no one's threatening you to give up your right to plead guilty?
That's right.
Okay. Factual basis.
Thank you, Your Honor. And I did just want to note, I have only received documentation for the 20th and 22nd.
Correct, I just arraigned him on the other two. the last two ones, and he just said he wants to plead guilty to all of them, which he tried to do at the last hearing, to be honest.
He did, Your Honor.
so.
It's actually the newer ones I've received. I haven't received the
Oh.
older ones.
Weird.
But he made quite clear to me this morning or today, it did not matter. He was intending to plead to them. So, Mr. Jackson, is it true that on or about December 17th of 2024, you underwent sentencing in front of Judge Simmons?
Mhm.
And
Yes,
as part of the conditions of that sentencing, you were put on a term of probation?
yes,
And part of those orders of probation were to refrain or stop drinking alcohol?
yes.
And is it true that on or about the dates that the judge has previously read on the record that you did consume alcohol?
I did.
And those resulted in a positive scram or urinalysis test?
Positive.
Thank you, Your Honor. I believe that satisfies the factual basis.
Any questions from the prosecution?
None, Your Honor.
Or is satisfied with the factual basis? I'll accept your plea and find your plea to be freely, voluntarily, and intelligently made. There was a extensive update that was provided from Ms. Bayless. Ms. Bayless also reached out to me with concerns about Mr. Jackson's health. The original recommendation was to terminate probation, and that it was highly suggested that jail time be imposed. That his overall attitude while on probation has been between fair and poor, but acceptance of responsibility has been poor and overall progress has been poor. Says defendant has been on probation since December 2024, but has made zero improvements. He continues to engage in non-compliant behaviors. Additional relevant information was provided regarding his progress while on probation, including a litany of failure to test, some issues with testing, issues with completing the GED program, which was a free program, the issues with completing cognitive behavior therapy, which is a free program, is non-compliance with enrolling and completing intensive domestic violence treatment, which was ordered and not complied with. There were payments that were not made on either this file or the other file ending in 2765, and a failure to report to probation in February 2025. And then he did not meet with the probation the following month on March 3rd, 2025. The officer states that officer has made numerous attempts to motivate this client to complete his probation conditions. This officer specially referred the client to some free programming for both CBT and a GED, which he still refuses to attend. Additionally, during the report day on March 20th, 2025, the defendant reported the falling off the wagon and using alcohol and drugs on a bender. This officer expressed to the defendant serious concern of safety, and welfare due to not being able to monitor his testing as he is not going as directed. This officer, during each meeting with the client, addressed what could be done to help him and asked him what help could be offered. It should be noted the defendant at every meeting always expressed a want to not continue probation as it is too much. On June 12th, 2025, during the defendant's report day via Zoom, the client, before even starting the meeting, expressed to the officer he no longer wanted to do probation. Client even on June 20th, 2025, told the officer he had a phone conversation with the defendant where he reported he is still consuming alcohol, not engaged in his required programming, that he does not like being told what to do. Since the start of the defendant's probation, he has failed to engage or be motivated to complete his terms and conditions. The defendant continues to display non-compliant behaviors, a poor attitude, and no want for rehabilitation. This officer had serious concerns during the pre-sentence interview regarding the term of probation for this client due to the history of non-compliance and prior probation revocations. This officer does not believe the client is suitable as a candidate able and willing to complete probation successfully. We can make allocution.
Thank you, Your Honor. I believe Mr. Jackson would by and large agree with the summation of that report. That being that he's not someone who's capable at this point of completing probation. He's fully acknowledging of that. He's struggled enormously with the terms and orders of probation here, and he'll be the first to stand up and say it. Given that, Your Honor, he is asking the court to terminate his probation. I would note I conferred very briefly with Mr. Silverthorne, the original attorney of record on the underlying file, who noted at sentencing that this court had held 180 days in abeyance, given the successful completion of probation. My request today would be to limit, if possible, the jail to that, and I do believe he has 35 days credit already served.
He's gonna do 365 days.
Huh?
He's gonna do 365 days. I've never in the history of being on the bench, I know it's not been but short of 6 years, seen this many violations and a blatant disregard for court order.
Let's go.
Excuse me?
Let's go.
That's where you're going, but you're gonna wait till I'm ready. Put the bag down. And the reason why he's gonna do it is because he's not done anything. He's done completely nothing, even when it was free. I've had other violations, other attempts to try to bring him into compliance. He refuses. And so for his own health and wellness, he needs to sit down for a year and get some treatment while he's in custody.
Yes, let's go.
Understood, Your
That's
Honor.
what I need.
Excuse me?
Want to go home. Listen, I mean, totally what you say. Make this
Yes,
real.
No problem. 365 days, Ingham County Jail, credit for, I'm trying to see.
There was 35 days originally noted on the PSI. I don't know if he's accrued additional time since then.
Yeah.
I don't have any days on here.
Put your time in there.
I don't have a PSI here, and on my judgment of sentence, it didn't have any days noted.
And I went through Mr. Silverthorne's notes. He indicated
I'm trying to understand why he would have 35 days. Was he in custody?
he had originally on this a cash or surety bond, and I believe he was in custody for 35 days before that either converted or he posted. That was from November of 2024, I believe, through his sentencing. I can double check the dates. November 23rd of 2024, he was given a $10,000 cash or surety bond, and I believe that was when this started, the 35 days.
That's what I see. I do see that. Okay. Okay, I'll give him credit for 35 days. He'll serve the remaining balance in Ingham County Jail. No earned early release additional to the 35 days and no GPS title release.
She got credit.
35 days.
I'll get no easy. Dang.
We'll look for it.